This is Ben Alexander. I'm doing civil law, criminal justice, and I'm gonna go over the civil cases and the steps in every civil case. So you start off by bringing the suit to attention, and start by hiring a lawyer if you want one. You get to choose if you want one or not, and if you cannot afford one, then you will be given one. The lawyer files complaint with proper court, and so depending on how serious the reason for the lawyer being there is how you decide what court you'll be filing to. The complaint, a formal statement naming the plaintiff and defendant, describes the lawsuit. The court sends defendant summons. What it means by summons is it's a document telling them of the suit against them and requiring them to appear in court. Just give them place, date, time to be there, and why they're going to have to be there. Most of them will know why. The defendants get to respond, and they may respond to charges by having his attorney files answer to compliant. The compliant and answer together are the pleadings, and so they'll be pleading guilty or not guilty for the suit that's against them. So discovery is the process by which lawyers on each side gather evidence by questioning the other party and witnesses, and that's where we see this is like when all this stuff goes on behind the scenes, and when they're trying to figure out what's going on, how they're gonna attack it. The pre-trial discussions are judge might call pre-conference with both parties to clarify differences between two parties, and so what he'll do is he'll call them both up to the stand, try to figure out if they can settle this right then and there. Either party may propose a settlement at any time during the whole process. So one of them could say, all right, this is what we'll try to avoid the whole process of going to trial and just doing all that. So here's a settlement, and the other side can choose to accept it or decline it. If they decline it, they go to trial. There may be a jury of 6 to 12 people. Judge also could just hear the case alone. The plaintiff presents side, then defendant. Both sides summarize their case. Plaintiff has to present enough evidence to persuade the judge or jury that the defendant, more likely than not, was responsible for the incident that caused damages. And that's what everyone knows to be what a trial is like. When you see the lawyer up there saying, my side is not guilty because, and then gives his evidence, and then the trial, and after all evidence is presented and arguments have been made, judge or jury will consider the case and decide on a verdict or decision in favor of one of the parties. If the plaintiff wins, a remedy is set, which is a payment. If the defendant wins, plaintiff gets nothing and pays court costs. So it's equal, and it's a long process. And then if you lose, you do get to send an appeal. An appeal would be the losing side may appeal the verdict, which is saying if you're guilty or non-guilty, and they get to send that to a higher court. And then the higher court decides if it's worth their time or not to take it in and keep the case going. Sometimes plaintiffs never see the money owed to them by the defendant, or have to wait many years, and that really makes people upset. But it is what it is, and that's the criminal justice system, as step by step and how it works. So yeah.